gonna stay right there. We're just gonna suck in.
I talked to your dad this morning. He was really concerned because they didn't have no names. I called the court first thing, and they assured me that you were on it. And also they got a hearing piece so that James can hear. Yeah, they had to order it from the county so he can hear a little better. Mario was also going to ask if there's any way they could reclassify him. Because he's been in what's called which is like you're in the normal part of the gym, but he's has lights on 24 hours a day. It's from where they got so that's weird. But with the they keep the lights on 24 hours a day. They strip them. Like do restrictions things. You guys have your lights off and on, right?
I do. Some of them don't.
Some of them don't. The ones he's in don't. And then they just stop so guys are screaming all the time. So it's like I think it's because I'm so used to saying I. Because most of my clients end up being I.
Yeah, I'm just gonna log in. Good morning, James. Hey, Mariel, can I have a pencil too? Yeah. I left without a notepad, but I had everything like written down and typed out. Thanks. Today's Mariel's 40th birthday, you guys. Doesn't she look older? Okay. I called her and I said, "Is this Mariel? You just sound so old." The jail visit you have later today, can you do it by video or do you have to go there?
Video.
Oh, good.
All right.
I didn't know how they were
Court
doing
is
that.
now in session. The Honorable Shirley Matthews presiding.
Marty, you may be seated.
Your Honor, calling People v. James Crumbly, case number 22-279-989 FH. Calling People v. Jennifer Crumbly, case number 22-279-990 FH.
Good morning, Your Honor. Karen McDonald appearing on behalf of the people of the state of Michigan.
Thank you. Mark Keast on behalf of the people.
Good morning.
And good morning, Your Honor. I'm Shannon Smith. To keep it easier for the court, I'm going to continue to represent Jennifer Crumbly.
Good morning, Your Honor. Marielle Lehman on behalf of James Crumbly.
Well, I hope you're feeling better.
I am, thank you. I'm down a gallbladder, but doing much better.
Glad to hear that. Well, you can all be seated. There's an agreed upon joint representation waiver form, correct?
That's correct.
That's correct, Your Honor.
And are your clients prepared to sign this form?
They are, Your Honor.
They are, Your Honor.
Okay. So I'm going to ask each. You can stand if you'd like, or
Go ahead and
sit.
stand up.
Could you both raise your right hand? Could you raise your right hand, Mr. Thomas? Do you swear or affirm the testimony you're about to give is the truth, so help you God?
Yes.
Yes, sir.
All right. You can put your hand down.
You know, Your Honor, we had asked Ms. Burgess if there was a earpiece Mr. Crumbly could use. He's hard of hearing.
Oh.
I know that an order was placed to the county. He has just
I was not aware of this at all.
Okay, I emailed your chambers. Is it possible if we just check and see if it's available?
Yeah, it's a court administration issue. This is the first I've heard of that.
Mr. Crumbly is indicating he can hear you. He's saying it's okay for today.
Okay, well, I'm glad you made me aware of that. Okay. I think they might be writing it down. It's at the court administration. But this is the first time I was made aware. Can you let me know if you can't hear me? It's important to hear everything I
Yes,
say.
Your Honor. Thank you.
Okay. All right, so you can both put your hand down. Could you tell me your name
Jennifer Crumbly,
and your name?
James Crumbly,
And how old are you?
44.
45.
Can you read, write, and understand the English language?
Yes.
Yes.
Could you hear and understand? Can you hear and understand me?
Yes.
Yes.
Could you hear and understand your attorney?
Yes.
Yes.
And are you satisfied with the advice of your attorney?
Yes.
Yes.
And you understand that you are charged with 4 counts of involuntary manslaughter. Do you each understand that?
Yes.
Yes.
Do you understand you have a right to have your own attorney, and conflict-free representation? Do you understand that?
Yes, Your Honor.
Yes, Your Honor.
Do you understand that there are various risks related to joint representation, and that they can include the following? Joint representation can compel a lawyer to refrain from taking certain courses of action during trial, before trial, and even after trial and sentencing. Do you understand that?
Yes, Your Honor.
Yes, Your Honor.
Joint representation can affect advice regarding the decision to plea negotiations themselves, and decisions during jury selection. Because a lawyer will have the duty of loyalty to both clients, the lawyer may not be able to suggest or take courses of action that would benefit one client but hurt the other. The duty of loyalty could prevent counsel from pointing out the differences between the client's culpability in potential plea negotiations or at sentencing, and making comparisons between the 2 clients. It could put one client at a disadvantage. Do you understand that, Mrs. Crumbly?
Yes, Your Honor.
Do you understand that, Mr.
Yes,
Crumbly?
Your Honor.
The duty of loyalty to both clients can affect counsel's decisions regarding matters of trial strategy. For example, it could limit the presentation of evidence, the examination of witnesses, or even decisions to call certain witnesses in an effort to protect the other client. As such, in the examination of witnesses, counsel may not be able to ask a question that would help one client but hurt the other. The duty of loyalty to both clients could also prevent counsel from pointing out the differences between the evidence against them, or from objecting to the admission of certain evidence as to one client. That is, arguing that certain evidence does not apply to one client can highlight its impact as to the other client. Being duty-bound to protect the interests of the other client can prevent counsel from being able to present a defense that implicates the other client. Do you understand that, Ms. Crumley?
Yes, Your Honor.
Do you understand,
Yes,
Mr.
Your Honor.
Crumley? There may be situations where counsel cannot effectively assist one client due to the necessity to protect the other. For example, if your co-defendant chooses to testify, your attorney may not be able to cross-examine them on any testimony that may implicate you or challenge your co-defendant's credibility. Do you understand that, Ms. Crumley?
Yes, Your Honor.
Do you understand that, Mr. Crumley?
Yes, Your Honor.
A lawyer has a duty to preserve their client's confidences and secrets, and either that duty may become compromised in the situation of joint representation, or counsel may not be able to share certain facts with one of the clients. Do you understand that, Ms. Crumley?
Yes, Your Honor.
Do you understand that, Mr.
Yes,
Crumley?
Your Honor.
Have you had the opportunity to consult with your retained counsel as it relates to the issue of joint representation? Ms.
Yes, Your
Crumley?
Honor.
Yes.
Have you been given the opportunity to consult with independent appointed counsel regarding joint representation and the potential for conflicts of interest?
Yes, Your Honor.
Yes, Your Honor.
Have you been given the opportunity for such consultation on understanding the risks? Do you wish to proceed with joint representation?
Yes, Your Honor.
Yes, Your Honor.
Do you understand that your attorney will not be able to act as a witness?
Yes, Your Honor.
Yes, Your Honor.
Do you understand that by entering this waiver, you will not be able to raise these issues in an appeal should you be convicted?
Yes, Your Honor.
Yes, Your Honor.
I'm going to ask that the defendants sign this form.
May I approach to grab it?
Sure, I know.
Your Honor, is it possible to uncuff their hands so they can sign?
By the way, I would have done that right at the beginning of the hearing, so could you uncuff so they can participate?
Thank you, Your Honor, very much.
Are you right-handed or left-handed?
Oh, right.
Just for the record, this is the same form that was admitted as People's Attached Exhibit G to the original motion, and it was read verbatim.
Yeah, it was supplied to me, and my understanding is that both defense counsels and the prosecutor agreed to this form.
That's correct, Judge. Thank you.
All right, thank you. Today's the date and time set for our pre-tax trial. I'm in receipt of the defendant's motion to modify bond and the response by the prosecution. I've thoroughly reviewed both motions. I've reviewed the transcript of the bond hearing at the district court and the transcript of the preliminary examination of the district court. I'm ruling on the motion pursuant to Michigan Court Rule 2.119E3. Pursuant to Michigan Court Rule 6.106H1, this court does not find an abuse of discretion by the district court judge. However, pursuant to Michigan Court Rule 6.106H2B, this court has jurisdiction and may make a de novo determination and modify a prior release decision. We look to Michigan Court Rule 6.106F, which dictates the relevant information that this court is to consider when determining pretrial release. First, defendant's criminal records. Based on the report of pretrial services, Mr. Crumley has older convictions for traffic offenses, including drunk driving and some old misdemeanor convictions for bad checks. Similarly, Jennifer Crumley has older convictions for traffic offenses, including drunk driving and a misdemeanor conviction for a bad check. Next, history of substance abuse or addiction. Although both defendants have a drunk driving conviction, those convictions are at least 17 years old. The court has not been receipt of any documented history of substance abuse or addiction. Defendant's mental condition, including character and reputation for dangerousness. Neither defendant has any documented history of violence, dangerousness, or a mental health condition. Seriousness of the offense charged, the presence or absence of threats, and the probability of conviction and likely sentence. These charges are obviously very serious. The sentencing guidelines in these matters indicate a prison term. The defendants argue that there is a low likelihood of conviction on these matters, while the prosecution indicates they expect to convict. I reviewed the testimony of the preliminary examination in this matter, where the district court judge found probable cause. However, this court finds that the probability of conviction in this matter is too difficult to gauge or predict. Defendant's employment status and history and financial history insofar as these factors relate to the ability to post money bail. Both defendants were employed at the time of these events, and their counsel seems to indicate that they would each be prepared to post a $100,000 cash or surety bond, but the court has no additional information beyond that. The court must next consider the availability of responsible members of the community who would vouch for or monitor the defendants. Defense counsel has indicated they would be willing to supply information with regard to this factor in confidence, although at the moment these individuals are unnamed and unknown. Facts indicating the defendant's ties to the community, including family ties and relationships and length of residence. The defendants owned a home in Oakland County and both were employed. However, neither defendant is still employed, and the defense indicates the home was sold and used for attorney's fees. Therefore, although the defendants appear to have strong family ties to Florida, the court is not aware of current ties the defendants have to this community. Last, the court must consider record of appearance or non-appearance at court proceedings or flight to avoid prosecution. Defendants indicate they were devastated when they heard about the alleged actions of their son, felt unsafe in their home, felt hounded by the press, and found it necessary to leave. However, the chronology of events that occurred subsequent to the defendants leaving their home is not consistent with cooperation with law enforcement. Defendants seem to allege some kind of foul play or deceit by law enforcement in their approach to the arrest of the defendants. Upon a warrant being issued, law enforcement is not required to make an appointment with the defendant. It is the job of the police to ensure a swift, safe, and secure arrest, and this court believes that would have happened but for the defendant's actions. The defendant's actions were premeditated to conceal their whereabouts. The defendant's alternative view of the chain of events cannot be reconciled. The series of actions by the defendants and resulting manhunt supports the prosecution's proposition that the defendants were fleeing the jurisdiction. The behaviors supporting flight are insurmountable, as the primary purpose of a bond is to ensure a defendant's appearance. The defendant's own actions leading up to their arrest make the current bond appropriate. Therefore, I'm denying defendant's motion to reduce the bond. I'm committed to providing the defendants and the prosecution with a speedy trial. A trial in this matter will not be routine. Arrangements to be made by this court to accommodate the trial, including juror summons and jury selection, will be extensive. So I want to know what motions to anticipate, as well as when you will be trial ready. I have a proposed trial date. So.
Okay, Your Honor, the defense anticipates filing approximately 10 motions at this time. I spoke with Ms. McDonald this morning to see if we can set up a time, either by phone or to do an in-person meeting, to see if we can get some stipulations versus filing the motions. We will be ready to start filing motions later this week and certainly next week. Okay. With respect to the bond motion, the defense is going to ask the court for a stay in this matter, only so that we can file an interlocutory appeal with the Court of Appeals. So if I can submit an order to the court today,
a stay of...
We have to ask the lower court for a stay so that we can file an interlocutory appeal on the bond issue. So I'm asking the court to stay this matter. I'm assuming this court's going to say no.
Well, I'm not prepared to staying orders, but I don't know why I need to stay it for you to appeal it.
Right. I'm required to ask, and you either have to grant or deny, and then if I don't ask, the Court of Appeals makes me come back and ask. So I can just put together an order saying it's denied, and then we can file our appeal.
The people would object to saying, Judge, we want a speedy trial.
Okay, yeah, I'm not going to stay. I'm not going to stay.
Okay, and that's just a pro forma order we have to follow.
Sure.
We do anticipate, in terms of our motions, mostly motions that would not require evidentiary hearing type issues. We have motions to quash, motions in limine, a motion about medical records of the shooter, motions about some much more minor things that I'm hopeful we can work out with the prosecution.
I'm assuming they don't work out a lot of your evidentiary issues.
Yes, Judge. Counsel and I will communicate.
Okay. You know, I would meet with you in chambers at some point if that was helpful too. I don't know if it will be or not, but you can let me know. Okay?
Yeah, that might be helpful too.
From the people's perspective, we would like a speedy trial. This has been, and I know the court is very much in tune with that. We'd ask for a scheduling order as well.
Okay, well, you know, I can give you the good news or the bad news. The bad news is because of the pandemic, we have them stacked to the ceiling, and I have other people that are still in jail. We have people, defendants who've been in jail over 700 days. On the other hand, my docket's quite good. So I was going to propose to you October 24th.
That's fine with us, Your Honor.
And I'm sure that's fine with us, Judge.
It might seem like a long time away, but I went through the calendar and I'm trying to avoid things like the 4th of July, Labor Day, and I don't want a jury, you know, during Thanksgiving or Christmas. And I guess I feel like if we don't start the trial in the fall, but then it won't happen until January. And I'm very cognizant that your clients, at least at the moment, are still in jail. So if you have a strong objection to that date, you should let me know, because my court administrator is here, and you know, the courthouse has already been moving heaven and earth for the pandemic, to accommodate the pandemic. But this trial will take a Herculean effort by court administration. So
Thank you, Judge.
So did you tell me on the motions you were going to file?
Just a couple of them, a motion to quash, some motion in limines, a motion regarding the shooter's psychological records that have recently been put together, a couple of very minor issues that we'll talk to the prosecution about.
Okay.
We're going to file a motion for a change of venue. There's about 10 that we have on our list, and we are working on them actively right now.
Okay.
So that we can just keep, we don't like to file, 20 at once. We'll file a couple next week, a couple more. We'll keep it moving so that it's not overwhelming one day
Okay.
with just a pile at the end. So,
All right. I appreciate that. How about the prosecution? Are you filing any motions?
Judge, I anticipate we will. I think at this point, most likely would be a motion for a non-standard jury instruction, as well as a motion limiting regarding the introduction of evidence. I think a lot will depend on the motions filed by defense, but we'll take it from there. And whatever scheduling order the court gives, the parties will adhere to that.
All right. Can I give you a scheduling order now, or do you want to wait till some of these motions are filed?
I'm fine with the scheduling order now.
Okay.
In particular, we were curious if the prosecution is using any experts, only because we would need to find rebuttal experts and that kind of thing. So,
You know that yet?
We'll let the court know as soon as that's determined.
Okay. Yeah, I think that both sides are familiar with cases where, someone's not available or something happens and you ask the court for an adjournment, the court is willing. I'm not wed to October 24th, but I'm now going to put the wheels in motion, and it's going to be a lot for the court. So it's not easy to change. So if you find that that's difficult, I don't. Maybe you think it should be sooner. I don't know. I do have other people in jail, but I don't have as many defendants in jail as most of the other judges in the courthouse. So.
Your Honor, I think that October 24th is reasonable. It does give us a lot of time. We could ask for something sooner, but then not be sure we'd be ready. I know myself and Ms. Lehman, we can be ready by that date. And if that can be a sure date, we will marry ourselves to it.
Because, you have Labor Day. There are, there's Rosh Hashanah. I want
right.
It's hard to predict how long the trial will go and how long it'll take to select a jury. I think probably it'll take at least a week to select a jury. Does that make sense to you? So,
Yeah, I would agree.
yeah. Okay. All All right, so if you haven't, if you look and you have your niece's wedding that week or something, let me know, but I'm just kind of floating that date to see if you'd all be available, all right? So I don't think I'm gonna do a scheduling order yet. I think I'm gonna wait till some of these motions are filed, all right? A trial date working backwards is helpful.
Well, we will keep things moving.
All right, thank you.
Thank you, Your Honor.
Your Honor, I'm sorry, one other matter, if I could. Mr. Crumbly is currently housing K-Block, Your Honor, and he's under constant monitoring, constant observation, 24-hour observation. He's housed with individuals who have some significant mental health conditions, as the court is well aware. The lights, it's my understanding that the lights are on 24 hours a day. Your Honor, I'm asking, and I know that Mr. Crumbly has previously made this request, we have not. I'm asking that the court direct the jail to reclassify Mr. Crumbly and allow him to move to a different unit. Obviously, if the jail has some concerns that they would like to share, we'd be more than willing to listen, but he's been on that unit since he was arrested and taken into custody. So I'm just asking that the court direct the jail to reclassify him and take these things into consideration.
Okay, well, I'll say a few things about that. Because of the posture of this case, I think all motions should be filed in writing, but I can tell you that I don't direct what the jail does. A separation of powers here, and I don't direct the jail. Mr. Bouchard does not listen to me. So if you find something in the law that would allow me to make that request, I potentially would, but there's a separation of powers for a reason I don't direct law enforcement. So
Thank you, Your Honor.
all right. Thank you.
Thank you, Judge.
All right.
Jennifer, we'll get you guys jail visits so that we can talk to you guys, okay? Hang in there. Come on, thank you. Okay, we will talk to you guys. Okay, James, we'll talk to you later, okay?